Timeshares. Overview of this unit is in Arizona, a subdivision is going to be defined as six or more lots or parcels created for sale or lease, right? Six or more lots or parcels created for lease or sale. This unit details the state requirements for subdividing property. It also details the state's requirements for developing a timeshare project. The unit is going to cover these topics. We're going to talk subdivision, public report requirements, amended public reports, exemptions to the public report process, lot reservations, rights to rescind, lot splits and illegal subdivisions, the affidavit of disclosure and case law, timeshare public report requirements, timeshare requirements, and right to rescind. So after completing this unit, you're going to be able to define a subdivision, list the major requirements for a subdivision public report, state the changes requiring amended public report, list 3 public report exemptions, describe the requirements for taking lot reservations, detail the rights to rescind a sale in a subdivision, discuss when an affidavit of disclosure is required, define a timeshare and discuss when a timeshare public report is required, define the right to rescind a timeshare agreement, and list the disclosure and other requirements for a timeshare agreement. So let's go over definition. A subdivision is land which is divided into 6 or more lots, right? So that subdivision is going to be 1, 2, 3, 4, 5, 6 or more lots. Parcels or fractional interests created for sale or lease. So subdivision, again, 6 or more lots. The commissioner must be notified of the subdivider's intent to subdivide through a public report. So what's a public report? It's a subdivision disclosure report, a statement of important facts relating to a subdivision, which allows a purchaser to make an informed decision regarding the property. The report must include name and address of owner and subdivider, liens and conditions on title to the land, terms and conditions of the sale, map of the subdivision, restrictive covenants, provisions for permanent access to the development site and to each parcel within the development. If in an AMA, active groundwater management area, the subdivider must obtain a certificate of assured water supply from the Arizona Department of Water Resources. So a complete list of all required items for a public report can be found in ARS 32-2181, and public report application forms are on the ADRE website. All right, so let's go true or false. A subdivision is 6 or more parcels created for sale or lease. This is true. When a subdivision is planned, the developer must prepare a public report and submit it to the Arizona Department of Real Estate for review. This is true. The public report is also known as a subdivision disclosure statement. This is also true. If a parcel in an Arizona subdivision does not have permanent access, the sale is not rescindable by the buyer once it is closed. This is false, right? So if a parcel in an Arizona subdivision does not have permanent access, the sale is not rescindable. So it is rescindable by the buyer once it is closed. So requirements for a subdivision: the commissioner may deny, suspend, or revoke the public report for incompleteness or inability to meet all statutory requirements. The subdivider must give the public report to buyers and have the buyer sign a receipt for it. The receipt must be kept by the subdivider for 5 years. amended public report. The commissioner may require an amended public report to be issued if there are material changes from the original. Once an amended public report is issued, the buyer has 10 days to review it and may cancel the purchase contract. Exemptions to the creation of a public report include the following: a bulk sale or lease of 6 or more lots to one buyer, the sale or lease of lots or parcels of 160 acres or more, the sale or lease of parcels zoned and restricted to commercial or industrial uses. Subsequent owner exemption allows a buyer, owner of an existing subdivision on which there is a current and accurate public report issued within the past 5 years, to use the existing public report. So, approval of a public report for property in an AMA could be denied due to unavailability of water. This is true, right? So, again, approval of public report for property in an AMA could be denied due to unavailability of water. A receipt for a public report that was signed by a buyer must be kept by the subdivider for a minimum of 5 years. This is true, right? So you gotta keep the public report for a minimum of 5 years. If a public report is amended, the buyer may cancel the purchase agreement. This is true. So if a public report is amended, the buyer may cancel the purchase agreement. The sale of subdivision parcels zoned only for commercial uses requires a public report unless also restricted to commercial uses. This is true. If a bank requires 6 or more parcels in the same subdivision through foreclosure, resale of the properties does not require a public report. This is false. So if a bank acquires 6 or more parcels, right, that's a subdivision, in the same subdivision through foreclosure, resale of the properties does not require a public report. It does require a public report. To qualify for a subsequent owner exemption to a public report, the original public report may not be older than 5 years. This is true, right? So it stems on the fact that you got to hold on to public reports for 5 years. A bulk sale of parcels in a subdivision is exempt from the public report requirement. This is also true. So bulk sale of parcels in subdivision is exempt from the public report requirement. The sale of 6 or more parcels of 160 acres or more requires a public report. This answer is false. So again, the sale of 6 or more parcels of 160 acres or more requires a public report. So if it's, it does not require a public report. So prior to issuance of the public report, the subdivider may only accept lot reservations. So the maximum is a $5,000 deposit per lot. It must be placed in escrow. The seller must deliver the public report to the buyer within 15 calendar days of issuance. A lot reservation terminates within 7 business days of buyer's receipt of the public report unless a purchase agreement is signed. A lot reservation may be canceled by the buyer prior to entering into a purchase agreement. If a sale is made prior to the final approval of the public report, or if the subdivider fails to provide a public report to the purchaser, The sale is rescindable by the purchaser, provided the purchaser takes legal action within 3 years. The right to rescind in the sale of unimproved lots by a subdivider. So a buyer has a 7 calendar days unilateral right to rescind. If a buyer has not inspected the land, the buyer has 6 months to inspect it and may rescind at time of inspection. Prior to a public report being issued, the subdivider may enter into purchase agreements with buyers. This is false, right? So prior to a public report being issued, subdivider may not enter into purchase agreements with buyers. With a lot reservation, the maximum deposit is $5,000 and may be placed in the developer's account. Answer is false. So with a lot reservation, the max deposit is not $5,000 and may be placed in the developer's account. So go back. So the max is $5,000, but it's not being placed in the developer's account. When a public report is issued, the developer has 15 days within which to provide the report to buyers with lot reservations. This is true. So when a public report is issued, the developer has 15 days within which to provide the report to buyers with lot reservations. After a buyer with a reservation has received the public report, the lot reservation will expire after 7 days if a purchase contract is not signed. The answer is true. So again, after a buyer with a reservation has received the public report, the lot reservation will expire after 7 days if a purchase contract is not signed. After how many days? 7 days. If a subdivider sells a property before the public report is issued, the buyer may not rescind the purchase. This is false. So if a subdivider sells a property before the public report is issued, the buyer may rescind the purchase. When buying an unimproved parcel from a subdivider, buyers have a unilateral 7-day right to rescind. This is true. So again, when you're buying an unimproved parcel from a subdivider, buyers have a unilateral 7-day right to rescind. When buying an improved parcel from a subdivider, buyers have a unilateral 6-month right to rescind. This is false, right? They don't have a 6-month unilateral right to rescind. All right, so would a person who owns 6 or more properties in an existing subdivision need to obtain a public report to sell or lease one or all? Yes. So a person, if you own 6 or more properties in an existing subdivision, you need to obtain a public report to sell or lease one of them or all of them. If 6 different LLCs with all the same members own 6 or more properties in a subdivision, would a public report be required? Yes, a public report will be required. If a person owns 6 or more properties and offer them for sale under a common promotional plan, is a public report required? Yes. So still, like if you own 6 or more properties, you need that public report. It's still required. How is an unimproved lot or parcel defined? An unimproved lot or parcel is a lot that is not an improved lot or parcel. An improved lot or parcel is one on which there is a residential, commercial, or industrial building, or concerning which a contract has been entered into to complete construction of a building within 2 years from the date of the contract. If a person owns or has ever owned 6 or more parcels in the same subdivision, must they prepare a public report? Possibly, but ARS 32-2181 allows the commissioner to exempt certain situations by special order. An example would be a very old subdivision on which no public report exists, and creating a new public report will create an undue hardship on the owner. A person who owns 6 properties in a subdivision must obtain a public report only at the time the 6th property is sold. This is false, right? So 1 or 6, still you must obtain a public report. LLCs that own subdivision property are exempt from public report requirements. This is false, right? Just because you're an LLC and you own subdivision property, you're not exempt from public report requirements. Marketing 6 or more non-contiguous properties under a common promotional plan requires a public report. This is true, right? Again, marketing 6 or more non-contiguous properties under a common promotional plan requires a public report. If a property has buildings on it, it is defined as an improved parcel. This is true, right? So again, if a property has buildings on it, it is defined as an improved parcel, right? If a person has ever owned 6 or more properties in the same subdivision, but never owned more than one at a time, they may be required to obtain a public report. This is true, right? So again, if a person has ever owned 6 or more properties, right, that's a subdivision, um, in the same subdivision, but never owned more than one at a time, they may be required to obtain a public report. So let's look at definitions of real estate language and concepts that represent a critical element of the licensing exam. So $5,000, right? That's the maximum lot reservation deposit, right? So $5,000 max lot reservation deposit. Sale of 160-acre parcels. That's going to be exempt from the public report requirement. So if you see that on your exam, if you see sale of 160 acres parcels, that's exempt from public report. Public report, what does that represent? That represents subdivision disclosure statement. Right to rescind. Typically, you have 7 days on the sale of unimproved parcels by a subdivider, and that is your right to rescind. Lot splits. So the creation of 5 or fewer parcels from one parcel does not create a subdivision. Therefore, it's common for landowners to split a large parcel into 5 or fewer parcels to sell the parcels without having to comply with the subdivision statutes. Cities and counties often have their own requirements and limitations for lot splits. A lot splitter and licensee should check with the local jurisdiction to determine these requirements. Orchestrating a scheme or acting in concert to circumvent subdivision laws is illegal. So lot splits, when we're talking about lot splits, it's the creation of 5 or fewer parcels, and it does not create a subdivision. So you want to check your local requirements. It's illegal to orchestrate a scheme or an act in concert to circumvent subdivision laws. Creation of 5 or fewer parcels, 5 or fewer from one larger parcel does not create a subdivision. Answer is true, right? So if you create 5 or fewer parcels from one larger parcel, that's not going to create a subdivision. Family members, friends, or adjacent owners who split parcels must be careful not to act in concert to create an illegal subdivision. This is true. So again, this is kind of a common case where people want to buy a lot of land and they want to split up their land, split up parcels, but they still need to be careful to not act in concert to create an illegal subdivision. Otherwise, they could be looking at a violation. Local and or county ordinances don't need to be consulted regarding subdivision requirements because state law always prevails. This is false, right? So again, local county ordinances need to be consulted regarding subdivision requirements because state law always prevails. So you want to check with their county, you want to check with the city, you want to check with the local ordinances to make sure you're doing your subdividing, you're being compliant with the regulations. So talk about affidavit of disclosures, ARS 33 -422, required in the sale of any property, improved or unimproved, commercial or residential, that is in the unincorporated area of a county, not located within a municipality, and not in a recorded subdivision. Requires disclosure of information regarding water availability, sewer or septic tanks, legal access, easements, and more. So an appraisal is not required. Must be delivered to buyer at least 7 days prior to closing. The buyer has 5 days to rescind the transaction from receipt of an affidavit. The seller must record the affidavit when the deed is recorded. Affidavit of disclosure, any property, so is in unincorporated area of a county, not in a city, not in a recorded subdivision. Affidavit of disclosure requires disclosure of conditions, must be delivered to a buyer at least 7 days prior to closing. The buyer may rescind within 5 days after receipt. Seller must record when deed is recorded. The topic is the right to rescind under an affidavit of disclosure. So let's go over a brief summary. So there's 3 similar cases were decided regarding ARS 33-422 on the affidavit of disclosure, which permits a buyer to rescind a contract to purchase real property. In each case, the buyers, which is Verma, had actual knowledge of a federal flood easement over the subject property within the time provided for due diligence under their contracts. In each case, the buyers affirmatively elected not to terminate the contract after learning of the defect in title created by the easement. Ultimately, however, the buyers attempted to extract themselves from the transactions by invoking the statute's express disclosure requirement and its guarantee of a unilateral right of rescission. In 2 of the cases, Burma versus Tilly Farms Incorporated and Burma versus Daughtry, the Arizona Court of Appeals concluded that the buyers, Burma, allowed their statutory rescission, the rights to lapse, and they are bound by the terms of their contracts. In the third, Burma versus Stir, the court concluded that the right was validly invoked. The statute provides a seller of 5 or fewer parcels of land other than subdivided land in an unincorporated area of a county, and any subsequent seller of such a parcel shall furnish a written affidavit of disclosure to the buyer at least 7 days before the transfer of the property, and the buyer shall acknowledge receipt of the affidavit. So the decision was, first, the court held that there is no upper limit to the size of a parcel subject to the statute. Secondly, the court held that the statute applies to parcels located only partially within unincorporated areas. Third, the court held that the statute is constitutional and that a seller's compliance with the statute is mandatory unless the buyer waives its rights. Compliance requires the seller to furnish an affidavit of disclosure that addresses those attributes of land identified in the statute's model affidavit of disclosure. Once an affidavit is furnished, the buyer's absolute right to rescind pursuant to ARS 33-422 exists for 5 days. The right may not, however, be exercised after the transaction has closed. Finally, an affidavit that contains inaccurate statements may give rise to a claim for relief at common law, in other words, for damages, but it does not create a continuing right to rescind beyond the 5 days allowed by the statute. So the application of this is that the sellers of the property that is not in a subdivision or in a municipality must provide buyers with the affidavit of disclosure. To protect the seller, listing agents should have the seller complete the affidavit at time of listing the property and provide it to the buyer at the time a purchase agreement is mutually accepted. The affidavit of disclosure is required on all property types, whether improved or unimproved. Additionally, licensees should make sure the most recent edition of the affidavit is used. So when selling a property that is not in a city and not in a recorded subdivision, an affidavit of disclosure is required to be given to the buyer. This is true, right? So you have to give that affidavit of disclosure to the buyer when selling the property. It's not a city. After an affidavit of disclosure is given to a buyer, the buyer may rescind the transaction within 5 days. This is also true. An affidavit of disclosure is not required in a sale of commercial income property that is not in a city or a recorded subdivision. This is false, right? So affidavit of disclosure, it is required actually in a sale of commercial income property that's not in a city or a core subdivision. An appraisal is required in an affidavit of disclosure. This is false, right? Affidavit is not required. An appraisal is not required in an affidavit of disclosure. An affidavit of disclosure must be recorded. Okay, the Verma versus Stir case affirmed the idea that a buyer who has not received an affidavit of disclosure when required by law may rescind the transaction prior to closing. This is true. So again, the Verma versus Stir case affirmed the idea that a buyer who has not received an affidavit of disclosure when required by law may rescind the transaction prior to closing. So if you don't get that affidavit, you can cancel the deal and rescind the contract. The Verma versus Stir case decided that a buyer who has not received an affidavit of disclosure when required by law may rescind the transaction after closing. So this is false. So again, the Verma versus Stir case decided that a buyer who has not received an affidavit of disclosure when required by law may rescind the transaction. So it's not a buyer. That a buyer has not received. That's false. All right, unsubdivided land. Property is divided. That's unsubdivided land. Unsubdivided land is when property is divided for the purpose of sale or lease into 6 or more lots, which are 36 acres or more each, but less than 160 acres each. That's called unsubdivided land. So unsubdivided land is when you have sale of 6 or more parcels of 36 to 160 acres each. An affidavit of disclosure, it must be recorded when selling property outside a municipality and subdivision. Parcels zoned and restricted from public report requirements are exempt from public report requirements. If you're acting in concert with others, you may be illegal. It may be an illegal method of circumventing subdivision law. Real estate timeshare is a share or interest in real property, usually in a resort, condo, or hotel, with a right to use the facility for a certain period of time. The sale of 12 or more timeshare estates or units require the developer to obtain a timeshare public report. Timeshare public report requirements, among other items, the application for a timeshare public report must include name and address of the owner and developer, the comprehensive statement of the timeshare program, legal description and location of the land, statement assurance for the installation of all improvements, including off-site improvements, provisions for the exchange of occupancy rights with owners of other timeshare projects. The right to rescind, a purchaser may, without cause, rescind a contract to purchase a timeshare within 10 calendar days of executing the contract. Blank spaces in the purchase agreement or public report make the contract voidable. Affidavit of disclosure applies to parcels of 160 acres, parcels partially in city or subdivision. I want to touch on this real quick. It says blank spaces in the purchase agreement or public report make the contract voidable. So when you have a blank space in your contracts, make sure you fill them in. Otherwise, it can be misconstrued as the contract is now void. If you don't provide an affidavit of disclosure, it's going to allow buyers to rescind prior to closing. There's no right to rescind after closing. So if you close on the deal, do you still have a right to rescind? No. Unsubdivided land, we talked about this, 6 or more. It's 36 to 160 acres. It's less regulated than subdivisions. The top 3 locations for timeshares is the ocean, skiing, and golf, right? So these are the top 3 locations for timeshares. A timeshare is like an ownership interest in real property with a right to use the facility for a specific time. The creation of 12 or more timeshare units requires a public report. Name and address of the owner. You need the comprehensive statement of the program. You need the legal description, assurance for offsite improvements, exchange privileges, disclosures. You have a 10-day right to rescind. Blank spaces allow rescission. So again, in your contracts, some of them, all of them are boilerplated and they have blank spaces. Make sure you fill in those blank spaces. Otherwise, it's voidable. And again, we're talking about timeshare. Other requirements and the timeshare requirements. If a sale is made prior to issuance of the timeshare public report, the sale is voidable by the purchaser. Legal action to void the sale must be brought within 3 years of the sale. The developer must give the buyer a paper copy of the purchase agreement at the time of signing. The agreement must contain a separate disclosure document that contains numerous required disclosures. Each disclosure must be initialed separately by the buyer. Other provisions, it's 3 years to rescind if no public report. It's a paper copy and it requires a separate disclosure document. The sale of 6 or more parcels that are 36 to 160 acres is considered to be subdivided land. This is true, right? Unsubdivided land, it's between 36 to 160 acres, and it's when you're selling 6 or more parcels. In Arizona, a timeshare public report is required when creating 12 or more timeshare units. This is true, right? So in Arizona, a timeshare public report is required. A description of exchange privileges with other timeshare properties. Description of exchange privileges with other timeshare properties must be included in a timeshare public report. This is true. In the purchase of a timeshare in Arizona, the buyer has a 10-day right to rescind. This is true. In the sale of an Arizona timeshare, the buyer may be given only an electronic copy of the agreement. This is false, right? In the sale of an Arizona timeshare, the buyer says the buyer may be given only an electronic copy of the agreement. No, they need a hard copy as well of the agreement. Any blank spaces in a timeshare purchase agreement make the agreement voidable by the buyer. This is true. So again, when you have purchase contracts, make sure there's no blank spaces. Otherwise, the purchase contract can be considered voidable. In the sale of a timeshare, a separate disclosure document must be provided to the buyer, and the buyer must initial each disclosure item for the agreement to be binding. This is true. So in the sale of a timeshare, a separate disclosure document must be provided to the buyer, and the buyer must initial each disclosure item for the agreement to be binding. So let's go over some of these key terms. Affidavit of disclosure, a disclosure document that may be required when selling property that is either in an unincorporated area, not in a city or town, or not in a subdivision, or if 5 or fewer parcels are involved in the transaction. It provides information about the certain aspects of the property and allows the buyer an opportunity to rescind the contract. Law reservations, that's basically an agreement between a developer and a buyer. It's usually accompanied by a deposit, obligating the seller to sell, but not obligating the buyer to buy. until after they have had the opportunity to review the public reports. Public report. This is where you have a disclosure document that a developer must give to buyers before they sign a contract that includes important facts about a property that would be essential to their decision making, also called subdivision disclosure reports, commissioners, or public reports. Real estate timeshare. So this is where the ownership of a single unit by multiple persons for fixed or floating increments of time over the course of a year, also called interval ownership. Subdivision. This is where you have multiple parcels of land that have been split off from a larger parcel of land. All right, so let's go over the unit summary. So we talked about subdivision is defined as 6 or more lots of parcels created for sale or lease. Before offering subdivided property for sale, the developer must prepare a subdivision public report. Subdivided property in Arizona must have permanent legal access. Buyers of subdivided property must receive a copy of the public report, or the sale is rescindable for up to 3 years after closing. If substantial charge changes are made in the subdivision, the commissioner may require the subdivider to create an amended public report. A subsequent owner exemption may be available if the original public report is less than 5 years old. Prior to the issuance of a public report, a subdivider may only take lot reservations. Maximum of $5,000 deposit may be taken for a lot reservation, and the money must be placed in escrow. On the sale of unimproved land from a subdivider, the buyer has a 7-day right to rescind and 6 months to rescind if the buyer has not inspected the land. The creation of 5 or fewer parcels for sale or lease does not create a subdivision, but persons who orchestrate a scheme to circumvent the law are acting illegally. An affidavit of disclosure is required in the sale of any property that is not within a city and not in a recorded subdivision. A timeshare public report is required for the sale of 12 or more timeshare units. That's when you need a timeshare public report. A buyer of a timeshare has a 10-day right to rescind. Blank spaces in a timeshare purchase agreement render the agreement voidable by the buyer. Timeshare developers must give buyers a paper copy of the agreement. So if you're into timeshares, you have to get a paper copy. All right, so we just wrapped up chapter 5. Now we're going to go into unit 6. We're just going to be talking about Arizona Commissioners Rules. All right, Commissioners Rules, the commish. Part 1, General Information and Advertising.